And I see that we have former representative and former chair of this committee, Joe Marino, present.
I move that we involuntarily defer.
I knew this was going to happen.
Such a pleasure to have you, Representative Marino.
Thank you.
Which, you want to do 269 or
269. If we
House Bill 269, Mr. Gonzalez, would you read the instrument into the record, please?
Thank you, Madam Chairwoman. Members, this is House Bill 269 by Representative Muscarello. It provides relative to the crime of a simple escape while participating in a home incarceration program.
And Mr. Gonzalez, do we have an amendment on that one? Can we offer that as well? Or can,
Mr. Gonzalez, if you read the amendment into the record, please.
Yes, thank you, Madam Chairwoman. Yes, members, this is Amendment Set 2160. And here's what it's doing. So amendments 1, 2, and 4 are technical changes. The real substantive amendment is in amendments 3 and 5. So amendment 3 is doing two things. It's removing the offenses of simple escape and aggravated escape from the venue provisions that are in Article 611C of the Code of Criminal Procedure that discuss venue and the offense being committed either in the parish where the offense occurred or where the victim resides. And it's carving out a new paragraph E in 611 of the Criminal Code of Procedure, which provides that if an offender is charged with a violation of simple or aggravated escape, the offense is deemed to have been committed in either of the following: the parish of the court that ordered or sentenced home incarceration, confinement, or any other legal restraint, or the parish where any act or element occurs in violation of RS 14110. That's a simple escape, aggravated escape statute. And then finally, Amendment 5, it's just removing proposed law from the present law, crime of simple escape in 14110, that provides for venue dependent on where the offense occurs. And that's what this amendment set in whole is doing.
I would offer that amendment. Do we have any objections to the amendment? Hearing none, let the amendment be adopted. Chair Muscarello, on your bill.
so before we start, this bill has been properly vetted. I want to thank Zach Gonzalez for the hard work that he's done. As you know, my colleague here, former colleague, is a meticulous reader of bills, and so this bill is in pure form, I can assure you. So I'll let him explain the bill to you.
Thank you.
Thank you, committee chair. We're doing two things with regards to the home incarceration, as it relates to home incarceration. Currently, under law, if you are on home incarceration and you live in another parish and you cut the bracelet, the crime of simple escape would only be able to be prosecuted in the jurisdiction where you cut the bracelet, not where the court who placed you on home incarceration is located. So we're adding in the venue statute, like other crimes that can occur in more than one place, the jurisdiction in 611, Article 611, which is the venue section. We're adding a new section E that says that if the offense is a violation of simple escape or aggravated escape, it can be prosecuted either where the offense occurs or in the parish of the court that ordered the home incarceration. That's the short version. And then the other part that we're doing is in the crime of simple escape, we're cleaning up the definition of what constitutes that crime. And we're also removing an obsolete section in another part that was not needed in law anymore.
Thank you. I don't see any questions by any members. We have green cards in support. Lieutenant Michael Dawson with the Gretna Police Department Home Incarceration, present, wishing to speak. Jill Dennis, Assured Supervision Accountability Program, present and wishing to speak. Lieutenant Dawson, Ms. Dennis. Good morning.
Good morning.
Just specifically, we've over the years, as you know, the Gretna Police Department has been running the Jefferson Parish Adult Home Incarceration Program since 2000, and over the past several years, we've had issues where someone is living outside of the parish of Jefferson. We've had them cut their bracelet. We issue a warrant for their arrest. They're brought back to Jefferson Parish, and the district attorney's office refuses to prosecute because it was outside of their jurisdiction. So the verbiage, the changes in the verbiage to the law is what we're looking at, and what I have heard will actually do that.
Thank you, Lieutenant Dawson. Pleasure to see you. Ms. Dennis?
Jill Dennis with the Assured Supervision Accountability Program. I had the pleasure last night to talk with Miss Elizabeth Hansard, who is the mother of a victim of a violent crime. The offender of this crime was wearing an ankle monitor. She wrote a letter she asked me to read. She said, "Thank you for allowing me to speak today on HB 269. As some of you might know, my son was a victim of an armed robbery on August 21st, 2022. He was left paralyzed from the incident. One of the offenders, Tata Se, was released on bail with an ankle monitor. 4 months after the monitor was placed on his ankle, he cut it off. He was on the run for 24 hours. It required the task force to go retrieve him. It should be noted that presently cutting off an ankle monitor is a misdemeanor. We're requesting that there should be additional felony charges for committing this new crime. It should also be noted that it shouldn't run concurrently with other charges. Having an ankle monitor is a privilege granted by the courts. When a violation happens, it puts the victims and the community at risk, and there should be consequences when this is violated. Please vote for this bill to help us make Louisiana safer. Thank you, Elizabeth Hansard." Tata Se was in the ASAP program. The ASAP program is a private program. It is not one that is monitored or run by law enforcement. This bill is a great bill. It is one that will make people accountable and responsible when they violate the privilege of being released on an ankle monitor. The only thing that I ask is that it include all court-ordered ankle monitors, not just ones that are run by law enforcement. The task force and NOPD and the work we've done with them allowed us to get Tata Se in custody in less than 24 hours. And because of the pain and suffering and the fear that Miss Noah and Elizabeth faced in that 24 hours was horrible. And the ability to be able to do what Representative Muscala and Mr. Marino has done is a great thing, and I do urge you to vote yes on this bill.
Representative Marino, do you have concerns that the bill doesn't address all ankle monitors? Is there anything?
So what she's saying is correct as well, because in 110, they have the sentencing provisions fall into B, and they have some unnecessary language that's really in numbers 1, 2, 3, and 4 that have like, and that's the language she's talking about. It says, a person participating in a home incarceration under the jurisdiction of law enforcement who violates Section A4. I mean, really, these, if we took out that first part and just put a person who, a violation of A4, here's the penalty, then that it's almost, she's right, it's excluding her if it's not run by law enforcement, and I don't think that's the intent of the law. So it could be cleaned up even further to just remove that first sentence, just a violation of Section A4, and here's the penalty.
It excludes a lot of adults that are in supervision, because a lot of the adults in supervision in Louisiana are done by private companies.
Absolutely. And thank you, Ms. Dennis, and Elizabeth, for pointing that out. Mr. Gonzalez, do you understand the amendment, and can you assist with that, please?
Thank you, Madam Chairwoman. It's my appreciation that on page 2, line 17 and 18, so I think what it would be doing is striking the law enforcement language, so it would be something to the effect of a person participating in a home incarceration program, and then strike the language under the jurisdiction and control of the law enforcement of their respective parishes. So let me read that in totality. So on line 17, starting on line 17 on page 2, it's going to state, a person participating in a home incarceration program who violates the provisions of paragraph A4 of this section shall be imprisoned, and then it goes on to state the imprisonment term.
Thank you. You agree, Mr. Marino?
Yeah, that'll catch 'em all. That'll catch 'em all.
I would offer that amendment. Do we have any objections? Hearing none, let the amendment be adopted. I see Chair Bacala is requesting to speak.
Thank you. Representative Marino, since you, Representative Muscarella's running the bill, I might vote for one of your bills.
You're not voting for anything for me. It's Muscarello. Don't worry about it.
But I would call, I don't know if there's an opportunity here or not. I haven't looked at the bill closely enough. I don't know if there's an opportunity here or not, but we have issues. I think the main issue with all of this is the lack of reporting for violations.
It's a different bill.
So
Article 874, which was introduced yesterday, will address that. That is adopted by Representative Kerner.
okay, well, I'll withdraw the question. Thank you. Thank you, Madam Chair.
Thank you, Chair Bacala. Representative Knox requesting to speak.
Thank you, Madam Chair. My question kind of similar to where I think Representative Bacala was going in terms of reporting. And I apologize, I didn't hear the beginning of your presentation, but what happens in the event that there's some damage already to the equipment,
I can address that.
to the ankle bracelet, for example? Is that what we're talking about? Or am I on the wrong?
If, no, sir. It's actually the cutting of the bracelet. If the equipment is not returned, then they are also charged with theft of the equipment. But and they can be charged with the removal of the equipment. In addition to the simple escape, it's all under the same statute of 110. But there is no damaging of the equipment, because generally what they do is they're cutting the strap. The strap is negligible. But when they cut the strap, they are then committing the crime of simple escape from the program. The equipment, because if it is GPS, we are generally able to get the equipment back. So if we're able to get the equipment back, then the individual is not charged with the theft aspect of the equipment. They're only charged with the crime of simple escape.
And just hypothetically speaking, if there were a situation where, for whatever the reason or cause, that it somehow came off on its own or was damaged in some kind of way, is there a process for that offender to self-report?
Rep. Knox, it's also the law, the penalty. I mean, the crime itself is now defined as the intentional alteration, destruction, removal, or disabling of the equipment. It's intentional. You have to have an intent.
Okay. All right. Thank you. I appreciate it.
Thank you, Rep. Knox. I do not see any further questions. And we have cards in support. Not wishing to speak, Philip Terrell, our Rapides Parish DA, present in support and will provide information if requested. Darren Alaman with the Jefferson Parish District Attorney's Office, present in support, will provide information if requested. Billy Joe Harrington, DA for the 10th Judicial District and President of Louisiana District Attorneys Association, present in support, but does not wish to speak. Mr. Curtis Nelson, Deputy Director of Louisiana District Attorneys Association, present in support, not wishing to speak. And Susie Labrie, present in support, not wishing to speak. We have 3 cards in opposition, not wishing to speak. Crystal Ramey, I believe, Jordan Gonzalez, and Chico Yancey. Chair Muscarella, you want to close on your bill?
I'll just ask favorable passage, but I will say apparently my colleague's missing a step since he's left the legislature, because he missed that very important little wording. So
We will forgive him, but we definitely thank Ms. Dennis and Elizabeth for catching that and for allowing us to make that very critical amendment. And we've got Chair Bacala requesting to speak.
Yes, Madam Chair, I'll withdraw my earlier motion to involuntarily defer and offer that it be reported with amendments.
Thank you. We have a motion by Chair Bacala to report the instrument favorably with amendments. Do we have any objections? Hearing none, let the instrument be reported favorably with amendments.